Four ex-cops have been indicted on U.S. civil rights charges related to the George Floyd death. Of course, who are we talking about? It's Derek Chauvin and company. We have Tou Thao, we have Jay Kueng, we have Thomas Lane, and of course, Derek Chauvin. And this is something that I think is not a surprise. Everybody was basically bracing themselves for this because we knew that the DOJ was already investigating them. And to catch you up to speed, if you're not familiar with the story, Derek Chauvin was convicted on all three counts in the killing of George Floyd. That was in a Minneapolis state court. So he's going to be sentenced and he's going to be serving time unless he gets a new trial. So that is already done and said. Now that is at the state level. We also have a federal level. The federal government now has been investigating these officers for different types of charges. And now a grand jury has indicted them. So let's go into the story. Then we're going to take a look at the actual indictments themselves from federal court. So first and foremost, we're going to go over to AP News. Tells us here that a federal grand jury has indicted four former Minneapolis police officers. They're saying that they willfully violated the black man, George Floyd's constitutional rights as he was restrained face down on the pavement and gasping for air. We all know that Chauvin was convicted last month. They were saying that they're also charging these people with violating Floyd's right to be free from unreasonable seizure and unreasonable force by a police officer. Tou and Kueng, they're also charged with violating Floyd's right to be free from an unreasonable seizure and accused of not intervening to stop Chauvin as he knelt on Floyd's neck. So they're all charged with failure to provide Floyd with medical care. And so we're going to look at all these different charges as they're broken down in the indictment. They say here that Chauvin was also charged in a 2017 case. So if you remember, there was some stories going around that as the Floyd trial was unfolding, that there were a lot of incidents where Derek Chauvin had prior problems, right? Prior negligence or prior misconduct on his record. And there was a back and forth about whether or not the government was going to be able to talk about those things. And when the government tried to talk about those things, the defense said, well, if you talk about Derek Chauvin's priors, then we're going to talk about George Floyd's priors. And the judge said, yeah, that's pretty fair. So the judge decided instead, we're going to keep both sides out. Nobody gets to talk about those things. But because the feds can still continue to look into these, and because the statute of limitations apparently is not expired, they are also charging Derek Chauvin with civil rights violations from a 2017 case from one of those prior incidents of misconduct. This involves a 14-year-old boy. And in this indictment, let's see here, the indictment in Floyd's death was handed down about a week after prosecutors brought hate crimes charges in the death of Ahmaud Arbery. The Justice Department is shifting its priorities to focus more on civil rights issues, criminal justice overhauls, and policing policies. Lane, Thao, and Kueng made their initial appearances Friday today via video conference in the U.S. District Court in Minneapolis. Chauvin has not yet made his initial appearance. He's still in custody. He awaits sentencing coming up soon. Other officers face trial in August. Eric Nelson, the attorney who it was arguing and representing Derek Chauvin, left no comment about these new charges. He may not even be representing him. Eric Nelson may only be focused on the state law case and not the federal court case. So maybe, Chauvin is going to get a new attorney, or the police union or whoever is funding this defense, they're going to go hire a different attorney to deal with the federal charges because it's a whole different system. It's a whole different case. We have Ben Crump, the team of attorneys for Floyd's family, say that the civil rights charges reinforce the strength and the wisdom of the Constitution. Yeah, it's a lot of strength and wisdom there, $27 million worth. Al Sharpton said the federal charges show the Justice Department does not excuse it, nor allow police to act as though what they do is acceptable behavior in the line of duty. What we couldn't get them to do in the case of Eric Garner, Michael Brown, Ferguson, countless others, we're finally seeing them do today. And I'm very curious about this. We already know that juror number 52, Brandon Mitchell, who was a part of the underlying state level trial. I'm talking back about the state law case. We know that this juror basically lied on the form. I think it's kind of unequivocal at this point. The form question, have you been to any protests that had anything to do with police brutality or police use of force? He said no on that. Well, he did, in fact, and he wore a shirt to prove it. And there's multiple pictures of that. We've already covered that ad nauseum. But now we have this new federal case on top of that. So the point is, if that juror was problematic, if that undermines the legitimacy of the final verdict, if we're going to get a potential new trial, now we have another federal case on top of it. So remember what the big complaint has been with Chauvin already thus far. It's that he didn't get a fair and impartial trial. $27 million settlement, Maxine Waters. The list goes on and on and on. No change of venue, the Dante Wright shooting, no revoid dire of any of the jurors except but for the settlement. And the list goes on and on. Now we have the potential for Derek Chauvin to be remanded for a new trial, and we have the federal Justice Department coming out and charging him with new crimes. So now everybody's going to know about that. So if Derek Chauvin does, in fact, get a second trial, now we're going to have to ask about that and Dante Wright and Maxine Waters and the 27 million. And it's on and on and on. So what's happening is we're seeing a dog pile from other areas of the country. Everybody's just dumping everything on right now. And it's going to impact the ability to get a fair trial down the line if that does come to fruition. We go back to the article. Minnesota Attorney General Keith Ellison, whose office is prosecuting the state charges, said the federal government is responsible for protecting the civil rights of every American, and federal prosecution is entirely appropriate. To bring federal charges in deaths involving the police, prosecutors must believe an officer acted under the color of law or government authority and willfully deprived someone of their constitutional rights. That's a high legal standard. An accident, bad judgment, simple negligence on the officer's part isn't enough to support federal charges. Prosecutors have to prove the officer knew what he was doing was wrong in that moment, but did it anyways. Right? How do you prove that? How do you prove that without Derek Chauvin's testimony? They got to get into his mind. That he knew what he was doing was wrong and did it anyways. How do you prove that? Difficult. If convicted on the federal counts, the sentence for each officer would be based on complicated formulas and sentencing guidelines. Yeah, that's true. In Chauvin's case, if the federal court uses second-degree murder as his underlying offense, could face anywhere from 14 years to more than 24, depending on whether he takes responsibility. Former federal prosecutor Mark Osler, U.S. University of St. Thomas Law School, said that guidelines clearly state that any sentence would be served at the same time as the state sentence. So he's saying that they would be running concurrently. So let's say, for example, Derek Chauvin is sentenced for 10 years in state court. Then he goes over to federal court and he's sentenced to 14 years. Oh my goodness. He's got two sentences. What happens? They start at the same time, right? Or he would get credit for both of them. So in other words, he would not have to do 10 years and then stack 14 on top of that. He would be able to get credit for the time served. So basically, he would be serving 14 years. 14 would include the 10 because they're running concurrently. The indictment in Floyd's death says that Thao and Kueng were aware Chauvin had his knee on Floyd's neck, willfully failed to intervene, they say. The other indictment against Chauvin only alleges he deprived a 14-year-old of his right to be free of unreasonable force when he held the teen by the throat, hit him in the head with the flashlight, held his knee on the boy's neck and upper back while he was prone, handcuffed, and unresisting. According to a police report from the 2017 case, Chauvin wrote that the teen resisted arrest, and after the teen, whom he had described as being 6'2" and 240 pounds, was handcuffed, Chauvin used his body weight to pin him to the floor. The boy was bleeding from the ear and needed 2 stitches. So that's great. So we have more confirmation that Derek Chauvin is actually human garbage. So that's a lot of fun. Now, it's not indicative that he killed George Floyd, right? He can be a overly aggressive, terrible human being, but doesn't mean that he caused Floyd's death. All right. FBI says 4 former Minneapolis police officers have been indicted on federal civil rights charges for the death of George Floyd. He's also been charged with a separate indictment for violating the rights of the juvenile. This is the statement that comes over from the Justice Department. We're not going to read the entire thing, but you see a lot of this mirrors what we've already talked about. The 3-count indictment alleges all 4 defendants acting under the color of law violated Title 18 U.S. Code. Count 1 alleges that he, on May 25th, we have a Floyd charge, his right knee on the back and the arm. Count 2 says that Thao and Kueng willfully failed to intervene. That's for count 2. We have a separate 2-count indictment, also charges Chauvin with willfully depriving the Minneapolis resident, 14 years old, of his constitutional right to be free from the use of unreasonable force, held a teenager, struck the throat, hit him in the head with a flashlight, and continued to have his knee on his neck and upper back after the teenager was lying prone, handcuffed, and unresisting. So he had a very similar case, it sounds like, in 2017, and the police department didn't do anything about it. Just let him keep going. So that's good. Both indictments charge violations of Title 18 If government employees like police officers use or misuse power, they're acting under the color of law. An indictment, this press release says, is merely a formal accusation of criminal conduct. The defendants are presumed innocent. Yeah, right. Does anybody believe that? Anybody believe the George Floyd cops are presumed innocent? Yeah, right. Until they are proven guilty beyond a reasonable doubt in a court of law. Charges announced today are separate from the Justice Department's of civil pattern or practice investigation into the city. Charges announced are also separate from the charges brought against the officers related to the state charges. Federal charges are different from criminal offenses, alleged different criminal offenses. Principal deputy, okay, and everybody else is very happy, congratulating themselves and listing their name. So we know what the FBI is doing. Not a surprise. Everybody was expecting this. We knew this was coming down the pike. We knew they've been investigating this for some period of time. There was some conversation even back during the Trump administration involving Bill Barr, where apparently they were discussing a potential plea deal. And according to some news sources out there, Attorney General Bill Barr under the Trump administration eliminated the possibility of a plea deal, which means that maybe they were also considering federal charges as well. Who knows? Don't know if this is a Biden thing or this is just a DOJ thing, but yeah, here it is. We have the general allegations. Oh, and by the way, let us not forget that this was coming either way, right? The feds had a plan in place that if Chauvin were acquitted during the trial, if the jury came back and said not guilty on all counts, they were going to arrest him anyways. They were not going to go through this process, though. So what I'm going to show you is a grand jury indictment. I've talked about this a few times on the show. Different ways you can start, formal criminal charges. One would be through sort of a direct complaint. The other is through a grand jury indictment. Two different processes that will get you to the same spot. But they had not done the grand jury indictment for Derek Chauvin yet. So if Chauvin would have been acquitted back during the state court trial, they would have tried, it sounds like, a direct complaint style approach for introducing the charges and then conducting the arrest immediately there. Obviously, that didn't happen. He was convicted on all 3 counts, and so he went into custody. That gave them time to submit this to a grand jury, and then now here we are. So we see that this was filed, scanned yesterday on May 6th at a U.S. District Court for Minneapolis. See that down here. We have the indictment. It says U.S. District Court for the District of Minnesota. So this is federal court. General allegations. Derek Chauvin was employed by Minneapolis police more than 18 years. Thao was also there for 8 years. We have Alexander Kueng started December 2019. Thomas Lane also started 2019. Floyd was 46 years old. Count 1, deprivation of rights under civil law. So they're saying that Chauvin did everything that we've already talked about, right? Floyd was basically willfully deprived of his right to be free from an unreasonable seizure, includes the right to be free from unreasonable force by a police officer. And you'll sort of notice here, right, that they're all saying that these are all in violation of 18 U.S. Code Section 242 and 2. Let's see where these other ones. Yeah, so 18 U.S. Code Section 242, and it goes on. So here we have count 2. This goes over to Tou Thao and J. Alexander Kueng. They say that they are same charges, right? They're willfully deprived Floyd from being free from unreasonable seizure. And we have another one down here. This is for all 4 officers. They're saying the officer's deliberate indifference to his serious medical needs. So 3 different counts in this one charge. We have a true bill signed off on by the foreperson, very likely, filed in court yesterday, 4 pages long, 3 different counts. That is the first indictment. Then we have a second set of indictments, or a second indictment with 2 counts that are going back over to Derek Chauvin. So let's take a look at that. This is, again, the indictment coming over from the same court. You're going to notice here that we have a juvenile. So we have the general allegations. Derek Chauvin at this time, back in 2017, looks like was employed for more than 16 years. Juvenile was a 14-year-old student resident of Minneapolis. Paragraphs 1 and 2 are incorporated. We have Derek Chauvin willfully deprived this juvenile of the ability to be free from unreasonable seizure, which includes the right to be free from police force. They say here that juvenile 1 was struck was held by the throat and struck multiple times in the head with a flashlight. This offense includes the use of a dangerous weapon, a flashlight, resulted in bodily injury to juvenile number 1. Chauvin, again, actively deprived juvenile 1 of the right to be protected by the Constitution and unreasonable force. Says that he held his knee on the neck and the upper back of juvenile 1, even after juvenile 1 was lying prone, handcuffed, and unresisting, resulted in bodily injury as well. So those are those 2 indictments. Now, we'll see if they're able to prove those moving forward, but they're going to have to deal with them. So my understanding is that the three officers have already posted bond. So everybody other than Derek Chauvin posted $25,000 bond. So they're all out of custody again. And Derek Chauvin has not yet made his court appearance, but he wouldn't be allowed out anyways because he's already been convicted. He has yet to be sentenced, but he's going to remain in custody absent the sentencing or absent a remand for a new trial. So let's take a quick look at some questions over from watchingthewatchers.locals.com, which if you want to support the show, that's the place to do that. First up on the program today is Liberty or Death says DOJ knows that Chauvin has a good cause for appeal and they don't want the other three to get off. However, wouldn't it be reasonable to assume that knowing the other three officers have been indicted federally would sway the state jury? Under the separate sovereign doctrine, they can still be charged by the state, but will the state give it to the feds? Yeah. So sort of the interplay between the two charges, right? So Liberty is saying, well, what about those three other officers? So now they have not had their trial yet. Derek Chauvin had his trial. So, all right, he's already been convicted. If the feds stack on charges on top of Chauvin, so what? How is he going to be prejudiced? Because he's already been convicted, right? How are they going to convict him again? So what? What is really the prejudice? Even if he was convicted again or is in federal court, those are going to run concurrent. So it's only going to sort of aggravate a current penalty that he's already serving time for because the jury has already found that he did that. So in this situation, with the other three officers, that has not happened yet. They have not been convicted of anything. Chauvin has, but they haven't been convicted of contributing to Floyd's cause of death or aiding and abetting or whatever the formal charges are there. That they still enjoy the presumption of innocence. So now we're sort of rewinding the clock, going back to the same concept. Now, what if different governmental bodies are dogpiling on one particular defendant because they don't want to lose the case? You got the feds now stacking charges on top of these other three officers because maybe they're concerned that maybe they walk, or maybe Derek Chauvin walks because Juror 52 blew the entire trial, and maybe this thing is coming back down for a remand. We don't know. It's a good question there, Liberty or Death. I think it is definitely worth toying around with. Are the feds improperly prejudicing these three still presumed innocent defendants? The middle sisters in the House says, why didn't the prosecution or the defense find the photo of the juror prior to or during the jury selection? So it's a great question. Maybe they just didn't find it. Maybe they looked, but maybe he deactivated his Facebook account. Maybe they were hiding some of this evidence, right? You can go on Facebook, deactivate it, reactivate it. Maybe they just didn't know to look. Maybe it was posted by an uncle. Maybe they didn't know the name of the uncle. So there's a lot of reasons why it didn't come out. But, the internet is a very powerful thing. I mean, I think the internet found that stuff, not, opposition research from the defense or the prosecution. The internet is way more powerful than any of those other consultants or agencies or tech, whatever. As soon as his name came out, Brandon Mitchell, because he sought that publicity, boom, right? You got tons of people with a lot of serious skills going in there and unearthing the truth about him. So I think that it was probably just a practical thing. Besimiento says they don't need to prove anything. Most juries have no clue. They either like or don't like the defendant. I've served on enough juries to know. Yeah, well, isn't that nice? Isn't that great? So are you saying that all my hard work is for naught, Besimiento? I know in many cases that you're right? I've seen this firsthand, and I'm being sort of facetious because it is frustrating, but I have done trials where I've walked into the room and I've looked at every juror's face and just gone, well, that's it. Don't even say a word. I remember one clearly going, ugh, because every single person just didn't like how I looked, didn't like how my client looked for some reason, or they had a bad day, bad morning, didn't get whatever they wanted in their coffee, but you could just tell. They just don't like you, right? And they prejudge, which is why I'm on here all the time screaming about the presumption of innocence, because it has been watered down to the point where really I don't even know that it exists. I think you can tell jurors, hey, presumption of innocence, and they still go, oh yeah, I know what that means, but I still think he's guilty though, right? That's fair. It's not how it works. _shade says, wasn't that teen literally trying to kill his mom? Thought there was a sister involved in it also. What was that one? Oh, are you talking about the 2017 case? So I don't know the backstory on that. Yeah, I don't know. I just know what we saw in the indictment. I don't know. Maybe there was some other context to that, but hitting a 14-year-old kid, cracking his head open with a flashlight sounds on the face of it doesn't sound good. Want to Know says, who is going to prosecute all the murderers' destruction during the protest? Aren't those illegal too? Where laws changed and no one died, dead people are still dead. It's now legal to burn down government buildings. Must be under new sensible murder and burn, destroy other properties laws that were passed. So want to know who is going to prosecute all the murderers if the police are defunded? I don't know. AOC, probably, right? Isn't she one of the people who wants to defund the police? Maybe she can take control of it along with Cori Bush and Jamal Bowden, I think is his name, and all of the other ones. They can prosecute everybody. All right, good questions. Once again, those came over from watchingthewatchers.locals.com. So if you want to support the show, that's the place to do it, and we really much appreciate it.